Hi everyone, and welcome to Alberta Human Rights, What Workers Need to Know. My name is Fiona Buchanan, and I'm responsible for communications at the Workers Resource Centre. Just a little bit about us. We're a charitable organization that helps Alberta workers, with issues like job loss, discrimination, improper pay, illness, disability, and a whole lot more. We provide free one-on-one support to workers experiencing these sorts of issues and provide them with information and support to help them navigate what can sometimes be some really tough situations. We also provide free workshops like this one to help workers understand their rights and empower them with information so that they know what to do and where to access support if their rights have been violated. Today's workshop is facilitated by our public legal educator, Kennedy Hughes. And Kennedy has been with us for over 2.5 years. And in this time, she has facilitated hundreds of workshops to workers across our province. During our workshop this afternoon, we invite you to ask questions in the Q&A tab that you'll see. It should be along the top of your screen. And we will do our best to respond to as many of your questions as possible. Now, I'd like to remind everyone this is a public forum. This workshop is being recorded and it will be made public on YouTube and other social media. So we strongly discourage asking questions that are personal in nature. Now, if you do have an employment-related problem that you require support with, please give us a call. Our number is 1-844-435-7972. And you can call that number between 9 a.m. and 4 p.m. Monday to Friday to set up an appointment with one of our caseworkers who can provide you with individualized support in a private setting. All right, I will now pass it off to Kennedy, who will be giving this presentation.
Awesome, thanks Fiona. Hello everyone, thank you for joining us this afternoon. As Fiona said, my name is Kennedy and I am here from the Workers Resource Centre to talk about Alberta human rights. We are going to start this afternoon with our land acknowledgement. In the spirit of reconciliation, we acknowledge that we live, work, and play on the traditional territories of the Blackfoot Confederacy, Siksika, Kainai, Piikani, the Tsuut'ina, the Ayaks Nakota Nation, the Métis Nation, and all people who make their homes in the Treaty 7 region of southern Alberta. So, before we start talking about Alberta human rights, it's important we understand what a general human right is. A human right is a basic freedom that every person has just because they're human. So it's a basic freedom that every person has, regardless of any internal or external factors. So some examples of human rights could be the right to life and freedom, the right to have your religion and practice that religion, the right to the freedom of expression and to have an opinion, and finally, the human right to get work and have an education. These are all considered human rights. Now, when we talk more specifically about Alberta human rights, there are two important pieces. The first is the Alberta Human Rights Act. In this act, there are a set of rules that protect you from discrimination. You are protected from discrimination based on personal characteristics about yourself. These personal characteristics are called protected grounds. We will talk about these protected grounds in 1 second. The second important piece is the Alberta Human Rights Commission. This is just the group of people who are in charge of making sure that all the rules written in this act are followed in society. So when we say the purpose of the Alberta Human Rights Act is to protect you from discrimination, what is discrimination? Discrimination means treating someone differently or unfairly based on who they are as a person. Treating someone unfairly based on personal characteristics. So some examples of discrimination could be a landlord won't rent to someone because of their skin color. A shop owner won't sell to someone because they are gay. And finally, an employer pays a woman less because of their gender. So these are all examples of people treated unfairly based on something they can't change, based on a personal characteristic. A good way to think of Alberta human rights is like an umbrella. Anything that's under the umbrella is considered protected from discrimination. So those are the personal characteristics, the protected grounds. Let's talk about what protected grounds are written in the Alberta Human Rights Act. Your race, color of your skin, your ancestry, and your place of ancestry are all considered personal characteristics where it is illegal to treat you unfairly based on these things. Your religious beliefs, including Indigenous spirituality, your gender, gender identity, expression, and your sexual orientation are all considered protected grounds. Your physical disability and mental disability, including substance abuse disorders or addictions problems, your age, marital status, and family status, and finally, your source of income. These are all considered protected grounds, personal characteristics where someone cannot treat you differently based on these things. So then on the flip side, what are some things that are not considered discrimination? Number one, your dress code. Your employer can tell you you have to wear black every single day. That is not considered discrimination. But if they told you you weren't allowed to wear a religious article of clothing, that would be considered discrimination because your religious beliefs are one of these protected grounds. Number two, opinion differences. Your boss can have different thoughts than you. That is not considered discrimination. Number three, bona fide job requirements. Bona fide job requirements are anything required for the safety and security of the position. So for example, if you are going to be a semi-truck driver, a bona fide job requirement to operate that big vehicle would be a specialized license, a specialized driver's license. So if you went to an interview for a semi-truck driver and you did not have that specialized license, they would be able to deny you the opportunity based on the fact you do not have the required safety and security requirements. Next, criminal record. If you have been convicted of a crime, your employer is allowed to deny you opportunities based on that conviction. Next, the Charter of Rights and Freedoms. The Charter of Rights and Freedoms is a national document for Canada that provides protections to its citizens. This was especially relevant during COVID. There is a big section in the Charter of Rights and Freedoms for public health. So, during COVID, employers were allowed to request vaccine passports or have masking policies. That was not considered discrimination because public health is written in the Charter of Rights and Freedoms. Finally, pay differences. Pay differences can exist in your workplace if someone has more education or more experience than you. They cannot exist based on someone's race or their gender. So now we're going to talk about some examples on if this would be considered discrimination. Your boss hates the hockey team that you cheer for. He is constantly nagging you about it. You notice that he schedules people who cheer for the hockey team that he likes for the best shifts and gives you the worst ones. Would this be considered discrimination? So the hockey team you cheer for is your opinion. Opinion differences are not considered discrimination. However, it sounds like a little bit of bullying might be happening here if you are getting all the worst shifts. So you could file something called a civil claim This is just not a violation of your human rights. Next example. During an interview for a liquor store, you are asked your age. Later, you find out they did not hire you. You think it might be because of your age. Is this considered discrimination? So this one depends. In Alberta, if you go into a liquor store, they are required by law to ask for your identification if you look under the age of 30 years old. So if I went in for a liquor store interview, of course I would be flattered. Clearly, I'm much older than 18. But it would be very hard for me to make the case that I did not get that job based on my age. However, if a senior citizen went in for the same job interview and they were not given the position, it would be a lot easier for them to make the claim that they were denied that opportunity based on their age. So there is a lot of gray area when it comes to discrimination. If something happens to you and you have a bad feeling in your heart, it is likely that you experience discrimination. I would recommend calling the Workers Resource Center to discuss your situation so our caseworkers can help you decide what the next best steps for you to take will be. Final example. You get into a car accident and you hurt your back. You can't do your regular job because it requires heavy lifting most of the time. Your doctor says you need modified duties at work until you recover. Your boss says he is not able to accommodate you and you are going to have to find another job. Is this considered discrimination? So your injured back is a physical disability. Physical disabilities is one of those protected grounds. So your employer would be required to give you the accommodation of modified duties. So what does accommodation even mean? An accommodation means making a change to anything. It could be policy, workplace culture, even the physical environment. Accommodation means making a change to help someone fully participate at work. Providing an accommodation removes barriers to create a fair and inclusive workplace for people who have different needs. So an example of an accommodation could be installing a wheelchair ramp for a wheelchair user, allowing prayer breaks for a religious person, or even giving time off of work for someone to attend a medical procedure. These are all considered accommodations, making a change to let someone fully participate at work. Another way to look at accommodations is helping to create a workplace free from discrimination. Your employer is required by the law to provide you with an accommodation up to the point of undue hardship. What does undue hardship mean? It means the accommodation is going to cost your employer too much money or take them too much time to implement. So for example, if you are a religious person and you need an area in your workplace designated for you to practice your religion, it would not cost your employer any money, and it would not take them any time to designate a small area for you to practice your religion. So they would be required to give you that accommodation. However, if you broke both of your legs and asked your employer to install an elevator in your building, that would cost a lot of money and it would take a lot of time. So your employer is able to deny that accommodation. Now that we've discussed that, let's talk about some examples of what an appropriate accommodation could be. Same situation as before. You are in a car crash. You have an injury in your back. You can't do your regular work duties because they require heavy lifting. What could be an accommodation for you? Maybe your employer gives you those modified duties. This could be something like administrative or inventory work. doing something on the computer until your back heals and you can go resume your regular duties. It wouldn't cost your employer any money, and it wouldn't take them any time to give you slightly modified duties. So they would be required to give you that accommodation. Another example, you are a single parent and you have to pick up your children by 6 o'clock from daycare. What could be an accommodation for you? Maybe you get an earlier shift, so you are off work in time to go pick up your child from daycare. You may not think when your shift is scheduled is considered an accommodation, but if you remember those protected grounds, one of the protected grounds is family status. So if you are a single parent and the only person able to pick up your child at 6 o'clock, your employer would be required to give you the accommodation of an earlier shift so that you can care for your child. Final example, you are struggling with a substance abuse disorder and you are finding it difficult to keep showing up to work. What could be an accommodation for you? Maybe your employer gives you some time off so you can attend a rehabilitation or treatment facility so you can get help with this problem. These are all considered accommodations in the workplace. So you realize you need an accommodation in the workplace. How do you get one? The first thing you need to do is be able to link or connect the accommodation you need back to one of those personal characteristics, those protected grounds. Sometimes doing that is really easy. If you hurt your back, it's really easy to connect that with physical disability. If you're a religious person, it's really easy to connect that to religious beliefs. Sometimes making the connection between the accommodation you want and one of the listed protected grounds is very difficult to do. Again, I would recommend calling the Workers Resource Center. Our caseworkers are very good at making that connection from your accommodation back to one of the protected grounds in the Alberta Human Rights Act. Number 2, you are going to have to let your employer know in writing that you will need this accommodation. During this time, you're going to need to provide any sort of documentation that you have. This will be especially true if you have a physical or mental disability, something like a doctor's note. During this step, you are also going to have to tell your employer about the duration or how long you will need that accommodation. Sometimes, if you hurt your back, you might only need modified duties for 6 weeks. But if it's something like a prayer space, you'll need it the entire time you work with the company. There is no set time frame for how long you can have an accommodation, but during this step, you should tell your employer how long you plan to need that accommodation. Step number 3 is having a collaborative discussion with your employer. Sometimes the accommodation you think you need is not the one your employer is willing to provide. So during this time, you can work together to try and find a compromise or some middle ground for an accommodation that will work for you both. During this time, you can ask questions, request documentation, and if you're unable to come to a conclusion, you can also request outside help for this conversation. That could be through things like a lawyer, an HR representative, or somebody at the Workers Resource Center. You can have somebody help you with this conversation to find an accommodation with your employer that works for all parties. We have a question in the chat box. Is political belief or affiliation an opinion or a protected ground? Good question. So that would be your opinion. Unfortunately, that is not considered a protected ground in Alberta human rights. It is so important to have written documentation of everything. If your accommodation request is accepted, denied, or needs to change for any reason, always request written paperwork from your employer. So, you feel you have been discriminated against. How do you file a human rights complaint? You can visit albertahumanrights.ab.ca. albertahumanrights.ab.ca. And that is where you can file a complaint online. You have exactly 1 year from the date that your discrimination occurred in order to file this type of complaint. Even if you wait 366 days, the commission will not accept your complaint. They are very strict on this 1 year timeline. So what do you need in order to file this type of complaint? You're going to need to provide the commission any correspondence between you and your employer. This can be things like emails, text messages, audio recording, video recording, any sort of conversation, written conversation that happened between you and your employer, you need to give to the commission. Then you need to give them any available documentation. This can be things like doctor's notes, previous accommodation requests, any sort of paperwork you have to give to them. Then you are going to have to tell the commission the story of what happened to you. Who said or did what? Where did it occur? What date and time did it happen at? Were there any witnesses? Tell them the story of what happened when you were discriminated against. Then you are going to have to provide the answer to the question, what have you done to remedy the situation? Unfortunately, a lot of Albertans experience discrimination. The Alberta Human Rights Commission receives a ton of complaints every single year. So, to try and cut down on the amount of complaints, if you experience discrimination, they expect you to take one step before you file this type of complaint. The one step you need to take is to report your discrimination to your employer. Okay? So before you file a human rights complaint, you need to report your discrimination to your employer in writing. If they do nothing about it, that's when you can go and file a human rights complaint. If you try to file a human rights complaint and you have not reported to your employer already, they will also not accept your complaint. You need to take the one step of report your discrimination to your employer. The final thing you will need if you are going to file a human rights complaint is patience. At the Workers Resource Center, we've had one human rights complaint. From the day we started until the day it was finished, took 5 years. So, if you have been discriminated against, a human rights complaint will take a long time to process. The best advice I have for you, be patient. Some people are nervous of filing a human rights complaint because they don't want to get in trouble. They don't want to be fired from their job. However, it is 100% illegal for your employer to treat you differently, get you in trouble, or fire you if you are filing a human rights complaint or if you are being the witness for someone else filing this type of complaint. If you feel your employer is trying to retaliate against you, write everything down. Every conversation you have with them, make sure you have written documentation. If your employer is trying to retaliate against you, the best practice is to stay out of a he said, she said situation. The best way to do that is to make sure you have written documentation of all conversations that happen. We have another question in the chat box. What if you don't have an HR person to take those complaints to the workplace? Does it go directly to the employer or the boss? Good question, Eva. If you don't have an HR person in your office, most of the time those complaints would go directly to your boss. If you feel uncomfortable with that situation, I would recommend calling the Workers Resource Center before you report that discrimination. They can help you have that conversation and make sure it is not uncomfortable or put you in a situation that you don't want to be in. Any other questions? What if you quit from the discrimination? Good question. So if you quit your job because of discrimination that occurred to you, you can still file this type of complaint because they sort of pushed you out of that by discriminating against you. So you can still file this type of complaint as well, even if it was your choice to leave your employment. Good question. So now you filed your complaint with the Human Rights Commission. What are the potential outcomes? There are 4 different potential outcomes. First, and at a minimum, your employer should issue you an official apology. If you experience discrimination at your job, the least your employer can provide you is with an apology. You could also ask for a reference letter so you can get a job elsewhere where you will not experience discrimination. You could also request that all of the staff attend a human rights training so they know what behavior was wrong and what to do better next time. Finally, and in my opinion, what you should ask for every time is money. There are 2 ways you can get money through a human rights complaint. The first is called wage loss. The amount of money you get for wage loss is really easy to determine. From the date you lost your job due to discrimination up until the point when your human rights complaint is complete. Any money you would have made during that time, if you hadn't lost your job, will be paid to you. The second way you can get money through human rights complaints is through general damages. General damages acknowledges that discrimination happened to you, and it can be really traumatic and stressful, and you deserve some compensation. Setting the amount of money you get for general damages payments is based on a lot of different aspects, like how long you have been working at the company, what is your salary, who did the discrimination. You get more money if it's a person in power rather than just a coworker. Another thing that can help set general damages payments is precedent. So you can go through human rights files and find one where someone experienced similar discrimination to you. You can say, that person received $10,000. I should also receive $10,000. I can tell you right now, in Alberta, the general damages payments are between $8,000 and $12,000 in 2025. Okay, so now we are going to talk about some frequently asked questions. Number 1, is my employer allowed to ask me about my disability, my family or marital status, or my age? The answer is no. At no point in the job posting, interview process, or while you are employed for the company, should they ask you about any past or present physical or mental conditions, medications, treatments, WCB claims, sick leaves, plans to have children, or your sexual orientation. If your employer ever asks you about any of these things, you can say, that is my personal information. I do not want to disclose this information. The only time when it is okay for your employer to ask you about these things, if it is for those bona fide job requirements, the safety and security of the position. So if you were going for an interview for a firefighting job, a regular duty of a firefighter is repetitively lifting heavy things. So a bona fide job requirement would be the ability to lift heavy things repetitively. So if you were going for a firefighter interview, they could ask you about your previous physical conditions because they need to be good enough in order for you to be a firefighter. Lots of the time when I show people this slide, the next question I get is, during my application process, I had to tell my employer about my race, my age, my gender. Why are they allowed to ask me about these things if it's my personal information? That question has a two-part answer. The first part of the answer is that asking about your race, your age, and your gender are considered demographic questions. So they are general questions. Asking about medical conditions or your sexual orientation, that's your personal medical information. So they are not allowed to ask about personal medical information. The second part of that answer is, in Canada, we currently have a DEI policy, diversity, equity, and inclusion. They want more women in the workforce. They want more people of color in the workforce. So they are allowed to ask you to voluntarily disclose demographic information about yourself. When it becomes discrimination is if you believe you were not given a job based on disclosing that personal demographic information. Is that easy to prove? Absolutely not. The best advice I can give to you, don't try and handle this situation alone. The Workers Resource Center is a free service dedicated to helping people in situations like this. So if you need support and resources, the best thing you can do is call the Workers Resource Center. Final question. What can I do if my employer fires me for filing a human rights complaint? You can visit albertahumanrights.ab.ca, and on there is a self-guided quiz. So you answer a bunch of questions and it leads you to 3 final answers. Number 1, what you've experienced is discrimination. Here's how you file a complaint. Number 2, what you experienced is not considered discrimination. Number 3, what you're experiencing is employer retaliation. Here's how you file a Section 10 complaint. So a Section 10 complaint is what you can file if your employer tries to retaliate against you, gets you in trouble, tries to fire you for filing a human rights complaint, or for being the witness for someone else filing this complaint. If you feel you have been discriminated against and you need help filing a human rights complaint, please contact the Workers Resource Center. It is always a free service. Are there any questions?
If there aren't any more questions for today, I think that should wrap it up. I just really like to thank Kennedy. I always learn something new in these public legal education workshops, so I really appreciate it. And thank you to everybody who came here today. I will be in touch shortly with the video, and I'll also email that link for feedback if you don't have time to do that right now. All right, thank you everyone, and I think that is it for today. Bye-bye.
Have a good day.